First case of the morning is State for Bromley. Each part about 15 minutes to present their arguments. You may reserve up to 5 minutes for how long would you like to reserve, counsel?
5 minutes.
All right, very good.
I don't know if it'll be that long.
As you know, we keep the time up here, so I'll try to let you know when you get down like a minute less than your time if that happens during your first part of your argument. The arguments are being recorded. Please stay at the podium. Please introduce yourself. Keep your voice up so we can hear you well up here on the podium. If you have the name of any child, minor, or victim during your argument to use, please use initials or from like the child. We have read your brief and are ready to proceed whenever you are.
Good morning, Giovanna Bremke on behalf of Mr. Zachary Bromley. May it please the court. I've presented 3 assignments of error in this case, and there are a somewhat lengthy version of facts. But essentially, my client and I'll use the initials because she was not convicted, but his co-defendant RB is his mother, and her neighbor MN have a long history together of sort of a dynamic there, a feud more or less. And RB, over the course of time, had told my client about this feud and things that had been done to her by MN. Now, it may become apparent to you that RB may have some mental health concerns, and I think that's documented in the record. However, she did articulate to my client, Mr. Bromley, that she was sexually assaulted in her sleep by the neighbor MN, and that my client himself had witnessed MN come out of his home, swing a golf club at my client's children, and my client had also had some PTSD issues from his own brother being murdered several years prior. So these events leading up to this incident were relatively close in time. As a result of these issues, my client's mother, who again is his co-defendant, asked him frequently to check on her home while she wasn't there because she was concerned about MN breaking into her home. On the day that this incident occurred, he had checked the home and apparently slammed the door shut. This drew the attention of the neighbor, MN, and he came out yelling aggressively at my client. My client indicates on the stand my client did testify. His mother did not testify. Of course, that goes to my first assignment of error. But he did testify that he was fearful for his life, and particularly fearful that this gentleman would retreat back to his home and bring out a knife or a gun. And because of his prior PTSD and prior instances with this individual, he wanted to make sure, and as he describes in his testimony, that he was down. So he did defend himself in that regard, and he also was struck by the neighbor. My first assignment of error is that the cases of the co-defendant, my client's mom, RB, and my client should not have been consolidated. Now, ultimately, she's found not guilty and he's found guilty. The state made a motion, and I believe this was heard on the morning of trial, to consolidate these 2 cases into one trial. The state did admit that, and I don't know, I don't have the transcript number, but I want to say it was, I don't have it written down, I want to say it was 21. The state admits that that there was statements made by the co-defendant, RB, that implicated my client. Statements made to the police. They did say, we are not going to bring these out unless she testifies. So that's ultimately why the court consolidated the case, but it restricted Mr. Bromley's ability to call her in the case because of that issue, and she essentially could not testify. My other assignments of error essentially revolve around the self-defense claim, which in subsequent recent cases, understand it's really more of a sufficiency argument on the self-defense. But again, these same issues that it was the neighbor who came to, approached my client, was yelling aggressively at him, he testified that he was in his face, that my client was fearful for his life, particularly because of these prior instances, and that my client himself was also struck. He was scared that this individual would go back and retreat and get a weapon, as he had done previously with the golf club. And he had this PTSD from this incidents with his brother being murdered. So all of that in consideration, I think that it's clear that he acted in self-defense and the conviction should be reversed. I reserve the rest of my time.
Yes,
questions?
Back to assignment of error number 1.
Yes.
The state kind of said there's some agreement on this being tried together. Did your client object when they talked about trying this together on the basis of, I might want to call the co-defendant at any time? In that discussion, why your client was objecting at trial?
Yeah, my client, I believe, did object. I don't want to speak without knowing, but I recall from the transcripts that there was argument either way. I don't think it was an agreement to consolidate the cases. I want to say maybe even there was a motion filed, I can double check that, but objecting to that consolidation.
Okay. You don't recall the basis of the objection though by your client trial?
I don't know, I don't.
Okay.
Thank you.
Thank you.
Good morning, Your Honors. Mark Coes on behalf of the State of Ohio, Lorain County Prosecutor's Office. Appellate counsel is correct that the state did say on page 21 of the transcript that one of those statements that the state was willing not to put forward would implicate Bruton. If you look further into that, the state filed a motion to consolidate, and both parties, RBs and Mr. Bromley, did file objections to the consolidation and motion in limines to keep out these statements. But as the record shows, that on the morning of trial there were discussions outside in judges' chambers, and then they came back in. Mr. Bobrowski, who was trial counsel for Mr. Bromley, did say that we've already addressed this, obviously in chambers with court amongst counsel. The state has made representations as to certain statements that would be limited. However, I reserve that right depending on how depending on how the course of the trial goes, to revisit both, especially the motion in limine as opposed to particular issues. However, at this point, I believe that we are in consensus amongst the parties. So, although counsel did initially file an objection, they were fine with it later. I would argue that this issue of consolidation was not properly preserved. As in my brief, I lay out that if they had an issue with this, they should have moved for severance at some point pursuant to Criminal Rule 14. Those points being to preserve this issue at the conclusion of the state's case or at the conclusion of the evidence. That did not happen in this case.
Counsel, can I ask you a question? So, my understanding of what happened was there was a motion in limine, there was objection and everything, and then the state said, well, we'll go ahead and not use the statement as long as you don't call them on. So they said, we think we have a consensus, but I think you just said, they said, but we want to reserve the right to revisit mom's testimony as well as, I can't remember now what else I was going to, but anyway, mom's testimony and the motion in limine, that's what it was. So anyway, what I'm asking is, we really can't say that that is a waiver, can we, or that you had an agreement, because it sounds like it was, if anything, it was only a partial agreement at that time.
I would agree with you that it was a partial agreement, but ultimately it was agreement with the state and the parties, and the state didn't end up using that statement. And RB, Rosemary, could have testified and did not testify at the trial. Initially, she did attempt to continue the trial and just go forward with Mr. Bromley's trial. but the court denied that after speaking with her.
So you're saying that he could have still called even though the state said that they would not use the statement only if she had testified?
No, what I'm saying, let me just get this correct. Ms. Bromley still could have testified in her own defense as to what was happening. She just chose not to. Now, I do understand that if she did, then the state would then be able to bring in that statement because it would have violated the agreement. But I think it was as you're saying, it was a condition on how the trial went. That's how both Rosemary's counsel and Mr. Bromley's counsel held it. So, looking at it further, that even if we say that this, so if there was a waiver, there's not a waiver, looking at these statements, ultimately there was just an agreement of the parties that the trial court didn't abuse its discretion by consolidating that. It was conditioned upon the agreement as stated, but ultimately, trial court, if the state said we're going to use the statement, then it would have been consolidated. So I think based on that, there was no abuse of discretion based on the trial court of consolidating these cases. There ultimately would be statements that would come in. With regards to assignment error 2, the sufficiency of the evidence, there was more than enough sufficient evidence to prove felonious assault in this case. MN testified that he answered the door to find Bromley outside it, and he does not remember what happens next. He wakes up the next 4 days later with facial fractures, abusive head trauma, life and limb threatening facial fractures. Ryan Bias, who was there at the time, heard, "If you ever do that to my mom again," and then she found MN covered in blood. Appellate counsel did say that self-defense, we failed to disprove self-defense, and said today again that it's a sufficiency issue. It's not a sufficiency issue, as this court decided in McElroy, and as the Ohio Supreme Court said, that is an issue preserved for manifest weight. It is not on the state to have an additional element to disprove an affirmative defense. With regards to assignment of error 3, I believe that it should be overruled. Additionally, too, as Mr. Bromley, through appellate counsel, did not develop an argument, just requested this court incorporate the arguments made in their sufficiency. Thank you.
Thank you.
I don't have anything further for rebuttal, unless there's questions.
I have a quick
Okay.
question. With respect to her initials of MH, not testifying.
RB.
RB,
Yes,
thank you.
the mother.
Are we left in a position that we have to speculate as to what her testimony would have been in order to sustain your first assignment of error? I mean,
I don't think so, because it's clear that there was, I mean, the state even conceded that there were statements that she had made that would have implicated my client. So even just, I guess, when you're talking about consolidation, you may ultimately always be speculating, because you're predicting what will happen in the trial before it happens, right? So I think you have to use the statements made based on what we know was made prior to trial to see whether there would be inculpatory statements, which there was.
okay, thank you.
Counsel, I'm not sure, I don't want to put words in Judge Hensel's mouth, but I guess what I was thinking she was meaning, and because I had the same concern, and that is, was there anything proffered as to how this testimony would have been useful, how he was prejudiced in regard to the fact that mother was not allowed to testify?
There was nothing proffered. I agree that would be useful for this court, but, and I wish attorneys use the proffer more frequently for purposes of appeal. But no, I think we are stuck using what is in the record, which there are, again, the state concedes there are statements that she could have made in her testimony that would have implicated my client.
Thank you, Judge Carr, you're right.
If nothing else, again, I would ask that you reverse this conviction and send it back to the trial court. Thank you.
Thank you. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the date of the ruling. The opinions are also posted on the High Supreme Court website. With that, on behalf of the court, I'd like to